ready. If you or somebody you know is going through a divorce and there is either current real estate or future real estate involved, this is a call and a webinar that you're not going to want to miss. I'm super excited to introduce and bring on the screen with me Michael Alvarez and Josh Barreda. And they are both with Barreda Law. Welcome, you guys.
Hey, Kelly.
Hello, hello.
Thanks so much for agreeing to just share your insights. And, you know, I've been a mortgage lender for over 27 years, and divorce is a very real thing. And I know it's your world, but even on the lending side, we often see people that have gone through the divorce process, it's finalized, and then they come to us, and either that's needing to refinance or they want to buy a new home. And there's so many things that go into that ability to get pre-qualified. So thank you so much for agreeing to kind of just chat with me today. And let's kind of dive into some of these things that people need to be thinking about, and especially if they think that they need or want to finance with a home loan downstream. Does that sound fair?
Absolutely.
Okay, cool. So let's talk a little bit about current market. And it's very often that we would see if there is a home that is owned, and let's say both parties are on the mortgage and both parties are on the deed, they have interest in the property. As they go through the divorce process, tell me kind of what you guys are thinking and any of the red flags or things that people should keep in mind as they're having that part of the conversation.
Yeah, well, and I'll go first, Josh. So I think the biggest thing I think people need to understand is if you're wanting to keep the home, or if anyone wants to keep the home and possibly refinance, that's likely going to have to come through an agreement of the parties that they can either work on themselves or that their attorneys can work on. Josh can speak to this a little bit more, but we're generally seeing, I'd say at least 9 times out of 10, if there are disagreements and the case goes all the way to trial, that the court's going to order that home to be sold, and neither party is going to get it, and you're not going to be able to keep that home or refinance. So that's the first thing that I would say is if someone gets into a case and they're really married to the home and they want to stay in the home and they have some type of emotional connection, they really do need to work with attorneys, real estate professionals early on to make sure they're going to be able to keep that. If they're waiting all the way till trial or it's getting, close to that time frame, the court generally is just not going to allow it because they've seen things blow up. They've seen cases come back to them where someone drags their feet on refinancing, or they're maybe having trouble qualifying on their own. And I know that's been a big issue now that, rates have gone up. So I think that's the basic thing people do need to understand, though. Start early. You really need the other party to agree to that if you're the party that is wanting to keep that home.
Yeah. And I would just add on to just an overall understanding of Arizona community property law, I think can be really helpful for, people in general and parties going through a divorce. Specifically, what I mean when I say community property law is it's just that if you are married and you purchase a home during the course of the marriage, Arizona views that home as community property, meaning you have an equal undivided interest with your spouse. Now, when that stops is the date that one of you is served with the divorce petition. So it's not the date that you move out of the house. It's not the date you separate. It's not the date you file for divorce. It's the date that you file and you actually serve the other side. At that time is when that community property legal designation now stops. So in theory, in the perfect world, we would really like an appraisal right around that time to identify what the value is per party and what equity or interest they have. Because as you know, Kelly, there's a difference between a mortgage payment where principal is paid and then interest is paid. And we're going to end up having to consult with financial experts regarding, who has what share of the equity there. So again, if you can, just like Michael stated, if you could really, focus on speaking to these professionals at the very beginning, understanding, community property laws in Arizona, and then how it may impact you kind of not just in the case, but after the case, which is more important.
Josh, thank you for bringing that up. one of the most frequently asked questions that we get, which obviously we're not giving legal advice, but it's with people saying, hey, I purchased a home with my spouse. I am not on the title, but so therefore I've disclaimed. Walk me through what that really means in a community property state, because I've had attorneys say, but that doesn't necessarily mean, even though they disclaim their interest, it doesn't necessarily mean that there isn't some ownership. Can you walk through that on a very broad, generic level? Because it is confusing. If they're disclaiming their interest, is that really disclaiming their interest?
And Michael, do you want to start with this? And I think what we're going to get into likely will be the Drehos formula and case in Arizona. So it's hard to do a bird's eye view of that because it gets down to a case in Arizona, to the nitty gritty. But Michael, go ahead, take the first stab, and then I'll do a follow-up if I need to.
And then Kelly, I think the confusion that you're facing, other professionals face, is the Court of Appeals has gone back and forth. Supreme Court's gone back and forth on these things. So if you were talking to someone a year and a half ago, 2 years ago, it would have been a different answer. So essentially, historically, it was if a party signs a disclaimer deed, they have actually disclaimed their interest in that property and in that home. Okay. So what that means is they would not be entitled to a 50-50 equity split. Essentially, they wouldn't sell it and get half that if they disclaim their interest. Okay. Now, I believe it was about 2 years ago, there was a Court of Appeals case that came out and said, we're not going to uphold disclaimer deeds for married couples, essentially. So this was a big kind of shock to everyone. But then the Court of Appeals reversed that and went back and said, no, they're disclaimer deeds. We need to uphold them. So it's kind of I'd say year and a half gap where things were a little bit wonky and disclaimer deeds really didn't mean anything. So if you were talking to someone in that time frame, then that was correct, right? Now, most of the time what I see with the disclaimer deed is a financing person says, hey, your credit's bad, or you have something in your past. We can't qualify if you're on the loan. So it's only going to be in this party's interest. The other person needs to disclaim their interest. Okay. Now, the Court of Appeals case law on that is pretty clear that even if that's the purpose, is that one party has bad credit, and I believe they call it for financial reasons or something like that, they're going to uphold that disclaimer deed. Okay. So this is the current lay of the land. They're going to uphold that disclaimer deed and say, it's not your house. So whoever, and that's even if it was purchased during the marriage. Now, and I'll let Josh talk about this, there's what's called a community lien interest in that home, which again, I always tell people it's nowhere near 50% of the equity. It's really based on principal payments and things like that. But that is the current lay of the land here. So anyone that's watching this that is still married or is, in the future, just know if you sign a disclaimer deed, it's going to be extremely hard to get out of that. You'd essentially have to show fraud, undue influence, coercion, which is a very high standard. And most judges are going to say, no, disclaimer deed, you're done. But I'll let Josh talk about the calculation, that community lien interest.
Yep. So like Michael stated, there is a case that's kind of on point with the lien interest. So there's a difference between, who is on the title, who's sold in separate property that real estate is, versus do I have value in there because I lived there for however long. And I guess, kind of bird's eye view, again, kind of looking back at the policy of that, it makes sense to me. Some people, it doesn't make sense, but it makes sense to me that when you're in a marriage, you're supposed to be building wealth, coming together, combining incomes, that traditional role that a lot of people utilize during a marriage. When you do that, the last thing on your mind is, I need to go purchase an investment property separate and aside from my spouse to make sure that I have an investment or retirement nest egg in addition to what we're creating together. So with that being said, say you are that spouse with that, that poor credit or that bad collections from, 2011 that's stopping you from getting the mortgage. You're in a position where you can still gain interest and equity into a home, even if it's not your titled property, right? So with that being said, really, it's just a case in Arizona. Again, it's the Drehos case. Drehos was just the name of some of the parties involved in that case. And the Court of Appeals used that name as Drehos formula. And with that, really, it's just a formula where they look at what the property was purchased for, what year was purchased, and then the appreciation of that property. and then the principal amount of the property. And there's just a pretty simple calculation that they utilize to determine, okay, this is what this spouse could be entitled to. Now, as far as it's not 50-50, when we run them, it's different because everybody's principal is different from everybody's equity as it pertains to the interest rates that was assigned to that mortgage. So when we run them, I see generally between, I'd say like a 15 to 20% split versus a normal 50-50 split, depending on how long the marriage is, of course. So again, it gets pretty dicey when it comes to that calculation. It's often, Michael and I, again, we don't claim to be mathematicians or financial experts when it comes to real estate or valuations, because what we normally do is we'll hire a forensic accountant, somebody that can do the calculation and be able to argue that on somebody's behalf in court if need be and testify. The issue that we see, though, is, my client will go seek an appraisal to try to get the highest amount. Their client would try to seek an appraisal to get the lowest amount. So then we start having competing appraisals, competing financial experts, and then competing valuations. I'll tell you, in general, just like with Michael said, if there's not an agreement, the court will order the sale of the property, and the sale in value will be the fair market value of what it sells for. That's easy as day, right? That's it. Or the court will say, if you have this value and this value, we're just going to split it right down the middle, right? This is the half range is going to be what we value the property at, and then we'll use the calculation from there. So yeah, it gets pretty nitty gritty there. And again, it's changed now a couple times in the past couple years. So I'm sure Michael and I and a bunch of other family law practitioners are waiting to see if it changes again.
There's so much to unpack there. So first, I just want to talk about community property states, because I don't know how many there are, but maybe 8 to 10 nationwide, because this will air on YouTube all over the country. So if you're in a community property state and you have disclaimed your interest in residential real estate, talking to somebody in that state, getting a legal opinion on how community property works in that state is important, because we're just now talking about Arizona, clearly.
That's correct.
Right. Okay. And then the second thing is, you touched on this, but it is important for people to know this whole appraisal thing. First of all, an appraisal is a subjective valuation based on that appraiser's review of the property. So it could be 2 different appraisals, 2 different valuations. It is important for people to know that it's not like there's one set price or valuation, and it could be different tomorrow if another comparable closes that is higher or lower, that's going to drive that valuation. Also, if you think that there's going to be a future appraisal for home lending that's going to take place on that property. So let's say that a married couple, one of the parties is going to retain the home and needs to refinance per the divorce decree. If the appraisal that's done up front in your beginning discussions is done by an independent appraiser, not associated with the home lending part, you're going to have a valuation. And then let's say 6 months, 9 months, 12 months later, you've gone through the process and the person that's going to retain the home is going to now start the refinance process, have the appraisal done. That appraisal is going to be specific to the home loan. That initial first appraisal and valuation will not have any impact on the home loan. And those numbers could be different. So not to complicate things, but I know how very hard it has to be for you all kind of giving this advice. You just say, oh, the house appraised at $500,000 on whatever, March 23rd. And then on December 23rd, that value could be $600,000 or $450,000. And so it is just literally a moving kind of piece there from just valuation to valuation. And people don't realize that a lender cannot go back and use an independent appraisal that was done that wasn't part of the lending process. So,
yep.
Any thoughts on that?
I have a few. Michael, do you have any first?
I think you hit the nail on the head as to why the courts don't really want to do the refinance and go through that hurdle. Because like I said, they're used to cases coming back, right? So the final decree comes out, so-and-so could refinance in 60 days, 90 days. It doesn't work. There's always some issue, rates rising, this person can't qualify. So then me and Josh are back in court, arguing, saying, flip it. Or, I mean, Josh even had cases where years later, 10 years after a decree, people come back and they're still arguing about it. So that's just why I think the courts are going to say, sell the thing. We know the value. The only other end around I've done is if the parties can agree on a value. And I guess, Kelly, I'll get your take on this. It probably wouldn't work for you guys, but at least in our decrees, I've had clients say, hey, we're agreeing the house is worth $500,000 and, we'll do payouts, something like that. I know for a fact, I know you're going to say, obviously that's not binding on a lender. You guys need to do your own process. But again, that's something I've done before, but it definitely does get tricky.
Yeah. And I think I'll just add that, again, I guess our best case scenario is we get that quote unquote appraisal that's not part of the lending process for argumentative sake, right? Is we're saying, Judge, this is what it's now. It's much better when value of properties go up, right? Because then both parties only stand to gain from that. The issue is, think about, our COVID inflated market prices, right? Where we did that, that appraisal, and it was $750,000. And now at the time of the trial we're coming up on, now we get an appraisal that's, $600,000. So what happens to that, right? Of course, my client would be still arguing for the half value of it was of the date of the community, that, the date that the other person was served. So we're running into that issue. So sometimes you can agree on a value, but then by the time you get to the lending process, it's like, well, you guys' agreement, it doesn't matter because it's actually this, or this is what the bank's saying it is. And if you're not buying this property or with cash or refinancing or anything like that, then guess what? You're going to have to go with what the lender states there. So that's an issue I see as well. Another issue is, at what point does somebody move out of that house? And does that affect their equity as well? That's an issue we run into. And then if somebody moved out of that house and they valued it at X amount that date, now, does the other person get a credit for maintaining that mortgage, the principal and the interest? And if so, then how much do they get reimbursed back, right? There's another case in Arizona known as the Bobro case that deals with reimbursements while somebody moves out of that property. So there's so many moving parts with that. But I think more information is always the best way to go, whether it be an appraisal when the divorce petition is served, whether it be an appraisal in the middle, and then an appraisal at the end. I'd rather have more data, more information, so that we can ultimately come to either an agreement or ultimately, again, the easiest form is just having the court sell the property and split the proceeds.
Yeah. I'd like to walk through this whole disclaimer deed because I don't think people understand. Let's say that you have a married couple and they start to converse. Maybe they're going to mediation. Maybe they're trying to go through the divorce process without legal counsel. I see people say, well, okay, you're going to keep the boat. I'm going to do this. I'm going to disclaim my interest in the property. And they don't realize that disclaiming your interest does not mean that you get to get off the mortgage. So if there's a mortgage on that property and that mortgage was taken out in both parties' names, you're both legally responsible in the bank size that gave you the loan. So disclaiming your interest does not necessarily mean anything to the big bank who, is out there. And I think just keeping payments current, once you go past 30 days late, because there's so many things that are going to happen downstream on future buys or refinances or things like that. I would just caution people to, before you sign a disclaimer deed, if you're currently on that home, talk to an attorney, get legal counsel, because you may be signing your rights away to the ownership of the property. Do you guys have any comments on that?
The only thing I would say is I have seen, bad scenarios where someone did disclaim an interest, like before we got a case, in the court still holds them to the community debt, which is on the house, but says they don't have an interest in the home. So again, that's obviously a very, very bad outcome. So again, yeah, I agree with you. Just really talking to an attorney. And then just, again, I agree that I don't think people understand what a disclaimer deed is and what it does. And this may be a question for you, Kelly, and I don't know if you go through that process, but a lot of times clients will come to me and say, no, a notary showed up at our house. we signed everything with the notary, and I didn't know what a disclaimer deed was. No one sat me down and told me, oh, this is what it is, or, So again, I think the courts do like to have information on what is that process like. Did the person know what they were signing? Again, most courts don't get into it because it's easier for them just to say, you disclaimed your interest, done, and the analysis is over. But that is something I've always wondered about, as far as how much. I know you guys can't give legal advice, which it may be legal advice, but I don't know how much you guys discuss that with people that are possibly signing a disclaimer deed due to credit history issues and things like that.
Yeah. It's interesting, Michael. The lending community has changed over the last, I'd call it 10 years. It used to be that if somebody could not qualify on the home loan, then they were not on the home loan and they were disclaiming their interest as a result of not being able to be on the home loan. But that's really changed. So today we will see and can close loans with a bona fide marriage. If a party can maybe not be on the home loan because of credit, but still wants to be on the deed of trust, that can happen today. And we see that more often. So it's a newer thing over the last decade. But then that also could have complications, because now you have somebody who has ownership interest in a property that isn't legally bound to the debt on the property.
Yeah,
so
there's no collateral. Yeah, there's no collateral attachment there. So if you're the bank, there's no upside there. It's only risk, and they're not going to do that in general. I guess any business shouldn't do that in that situation if you can't collect on that. And I think what people need to understand too, with disclaimers, there's a difference between disclaiming per the bank's requirements versus the title, right? So again, it's if you're married and you can't approve, for the actual finance of that property, you're going to have to disclaim one or the other, either the bank financing or the title itself. And I think, again, like any, high pressure real estate, big transaction, they come to your house. Hey, you have to sign all these things. This is so we can have a place, and it's at this price. And if we don't do it, the deal drops down. It's high pressure. So I guess it's easy for us to say, make sure you, seek a consultation, get counsel. But when they come over and they say, hey, you have to sign this for your spouse or your significant other to close on this property without there being any issues, potential lawsuits from the seller for that property, it is high pressure. So, part of the standard, in court is whether or not that person was coerced or under duress when they signed that, or whether they thought that was to benefit themselves or the community, the marriage. It certainly almost is to purchase a property that's going to benefit the marriage or an individual or both people at some point. So it's difficult, because if the situation was flipped, it's hard to prove that it wasn't going to benefit the community at some point. So it's easy to say, don't sign it, get counsel. But then again, I don't know any lender in any bank that's going to say, okay, well, go take a few days and then get back to me, and we'll have the same notary come back,
Yeah. And as we talk, we can just talk about this whole deed thing for an hour. But another scenario with Arizona being a community property state, if somebody is purchasing residential real estate and they're in a community property state like Arizona, and they're legally married, and they want to use a government-backed loan, so that could be FHA, USDA, or VA, FHA, USDA, so all government-backed loans. The lender is going to require that either the borrower be on the deed, the co-borrower who's in the marriage, but maybe separated, let's say, they're either on the deed or they're signing a disclaimer deed. And so that could be really complicated if you're going through the divorce process. So you're married, you're separated, you're going through the divorce process. One of the parties wants to go buy a house. From a lending perspective, we still need something to happen with regard to that disclaimer deed, which complicates, it can impact the divorce proceeding. So we're always very hesitant. And if you want to purchase a house and you are still legally married and you don't want your spouse on the loan or the deed, you need to go back in and get legal advice, because asking that spouse to sign the disclaimer deed or them agreeing to do that could impact either side as they move through the divorce proceeding.
Yeah, I've had that on quite a few different cases where, the petition has been served, they're separated. Most cases, I'd say in Arizona, contested. They take about, I'd say, 9 months to about a year and a half, sometimes 2, sometimes 3 years for these divorce trials. So obviously life goes on. People want to buy new property. They may have another significant other. So when that happens, the biggest issue is, again, they're still married at that time. You're just because you filed and served. So the deed would say, as a married man, as his sole and separate property, and there would need to be disclaimer deed signed. Now, if the other side is represented, the advice can be from the lawyer, don't sign anything. I don't want you to sign that. So then that can hold up the deal. Not to mention a huge issue that I've dealt with before on a case was that person wanting to buy that new property was using or trying to utilize community funds in a joint checking account, where those funds, if you trace them back, were funds that were utilized during the course of the marriage. It's like, well, now this, spouse of yours, who's soon to be your ex-spouse, has a lien interest amount in your property that you just purchased. So that adds another layer to legal complication that, again, my advice in general is please, please, please don't close or purchase a property while your divorce is pending. Like, let us finish this, or at least if that is what your intent is, let's all get in the same room. Let's draft up what's called in Arizona a Rule 69 agreement, which is basically, just kind of a placeholder while the case is pending to finalize, and then make sure that all attorneys are on board, do the appropriate signing, lodging with the court, have the court approve it so that there's no issues.
Yeah. And then, Kelly, the only thing I would add there is every community property state's different. But here in Arizona, being physically separated from your spouse means nothing. Okay. So again, California is a physical separation state, meaning once you physically separate from each other, you're having two different residences. That's going to be deemed when the community terminates, as long as they don't get back together and reconcile. In Arizona, physical separation means nothing. Okay. It's the date of service that generally will stop the community property from proceeding at that point. So again, divorce is very simple for everyone, but divorce it's a lawsuit. Essentially, you file a lawsuit against your spouse. It's called a petition for dissolution or divorce. That document then needs to be served on the other party. Once that date of service occurs, that in Arizona, that's when the community ceases. Okay. So, but again, like Josh said, technically, if you buy a house prior to your divorce being finalized, but after date of service, yeah, technically you're still married. So the deed will have to say this person, married as sole and separate property, but then you're getting into the issues of, and generally it's disclosure issues. So the other attorney may say, I need to trace the funds. Did they have a down payment? Where'd that money come from? So I agree with Josh. If you can avoid not purchasing a home while your case is pending, do that. I've had clients do it, against my advice, or just, and again, that's completely fine. Like Josh said, life goes on. And generally speaking, at the end of the case, it's going to shake out fine because they've been separated and the date of service happened. But again, you could be adding attorney's fees onto your case because you have to do more disclosure and you have to look at things and you have to bring in a financial expert. So that's all I would add to Josh's response there.
Michael, you mentioned rising interest rates and the impact of this refinance. If there is an emotional tie to the property and one of the parties want to retain it, I do want to make sure people understand that there could be an option for that low interest rate. Let's say that the property is refinanced or purchased in, the height of our low interest rate market, call it 2020, 21. There could be an opportunity to assume that mortgage with qualifiers, depending on the type of mortgage. It's important to know that conventional home loans are not fully assumable, but FHA or VA-backed mortgages might have assumable qualifiers there, meaning you still have to be able to qualify. You still have to be able to show documentation. You would work with the lender or the servicer of the current mortgage. You wouldn't go to a new lender, but you could inquire about assuming that very low interest rate mortgage. If it is a VA loan and the person that wants to assume it does not have VA home loan benefits, it doesn't mean that they can't assume it though. What it does mean is that the party that does have the VA home loan benefits, their benefits would continue to be encumbered if that spouse assumes the VA mortgage. Does that make sense? So sometimes, like I have a client right now who is going through the process. They have a VA home loan on the property. She wants to stay in the property. The interest rate's like 2.5% on a 30-year fixed rate. So there's a benefit to doing that, but he wants to use his VA home loan benefits in the future. So they're kind of arguing over the assumption or not, et cetera. So on VA in particular, important to know, she does not have VA home loan benefits. Therefore, the benefits, the entitlement would still remain encumbered. FHA is different. They can just, if it were an FHA loan, the spouse that wants to retain the home would go to the lender, get qualified, and could potentially assume that very low interest rate.
Yeah. And that's why I know Josh does the same thing. I always tell people, go talk to a financing professional. They're going to be able to explain that portion of it better, kind of explain your options to you. Again, I always go back to, if we go into a final trial and we're still fighting about who keeps the home, and we present a case saying, they can assume the loan in X, Y, and Z, the court probably still is going to say, I don't care. I'm going to order it sold and, move along. And as far as the emotional tie to the home, Kelly, you mentioned that. That's something I see a ton, which is it is a piece of property, but there is an emotional attachment and a connection there. And Josh actually had a case, I believe, where the Court of Appeals has essentially ruled you can't take into account, the children lived in the home and it's close to their school and all these things, which common sense, I guess we'd say, well, the court should be able to look at that, right? The children were there for 10 years. It's in the school district for the children. Isn't that good enough reason for the court to say, keep it? Court of Appeals said no. So again, just as far as anyone, if they're talking to their attorney, feel free to tell them that. I guess they could still, try to make a case there, but the court is not going to view that piece of property with any sort of emotional connection that the parties have, unfortunately.
Yeah. And just to add on to that piece, again, with divorce, if you're not dealing with the custody issues, the legal decision-making of children, what I always tell our clients, it is you are dividing a business between two people, that being your marriage, of all the assets and debts you guys have accumulated. So every decision you make has to be a cost-benefit analysis to it. And the only way you can do that is if you bring in every single professional that you can think of that could presumably, be relevant or important in your divorce case, whether that be, again, a loan officer, a real estate agent, an accountant, a lawyer, a business lawyer, if you have businesses to divide or value. So again, more information is better. And again, a lot of these, companies and professionals provide, free consultations. So, and then more importantly, once you kind of pick your team of professionals of who you're going to go with and who you trust, with this, very important and sensitive information, it's important that you provide all the contact information in between them so that I know what Kelly's saying or advising about a VA loan that I may not have no knowledge about whatsoever, or I don't know the difference between a, conventional versus FHA versus, is conventional still 3%, down compared to others, right? And then not to mention, I'm sure we'll get into this, but what kind of income you have, that's qualifying, and how long of a history you need. Because again, back to, what Michael said, essentially your runway to make that decision and get your team aligned is from the date of filing until the date of your divorce trial, which is typically, again, a year to 3 years if it's fully contested. So if you don't do that within that time, if you go into court with a complicated legal scenario of, values, appraisals, interest rates, and, say somebody took out a 401k loan, a HELOC, a second, all those things kind of complicate the case. And now at the end of the day, again, the judge is going to take the easy way out. That judge has 800 other cases on his or her calendar. The last thing that they're going to be doing is, looking at your financial experts' valuation reports.
From a lender perspective, I would encourage people going through the process to really work with their attorney to make sure that assets are detailed in the divorce decree. Credit is detailed, meaning, if it is a MasterCard, there's so many different MasterCards that if a lender can't connect what the divorce decree says with the account number that's showing on the credit report, then it's not always beneficial to the person that's wanting to take out the future home loan. So I would just say, unfortunately, more is better when it comes to just account connection, so we can read it a year later or 2 years later or 3 years later and match it to the credit report and say, oh, it was this MasterCard account ending in these 4 numbers that was discussed or, included in the divorce decree. Secondly, credit. I can't stress this enough. When people are going through this process, it's emotional. We see it. And sometimes there's joint credit where both parties don't know it's joint credit. So I highly recommend getting a copy of your credit report. It's early on in the process, so you know what's your credit, what is joint credit. And in my experience, contacting that creditor and saying, hey, I'm going through a divorce, I need to take Bob off. That's not the way it works. They're going to want you to close the account. So then that could create a drop in your credit score, depending on what other things are on your credit. So there's so much to know. And I think that, Josh, you said it well, getting your team in place so you can start to get the knowledge that you need to be able to navigate the entire process is half the battle, because people just don't know what they don't know until they're in the thick of it. So credit, assets, documentation. Let's move to income, because this is a hot topic as well. And so from an income standpoint, specific to home loans, there are a couple different things that come up. Child support is one, and spousal maintenance is another. And from a lending perspective, the lending guidelines will allow use of those 2 types of income, but there's rules around them depending on the home loan type that person is wanting to take out. So in general, if there's temporary orders that have identified, let's say somebody is paying child support, then if the lender can document that they have received that income, and it can't be variable, like a set income, for 6 months from the filing of that temporary, it doesn't have to be the final divorce decree, but it could be temporary orders. That would be enough that a lender could potentially use that for qualifying income, which many times people need. They need to be able to use the child support or the spousal maintenance to qualify for that home loan. So I just want to throw that out there and kind of have some conversation around it.
Yeah. Well, so I think the first thing that you noted, which is super important, is temporary orders. So like Josh said, if a case is taking a year to 3 years, if there are no temporary orders, then the case starts. There is kind of one status conference. We call it a resolution management conference, which is 5 to 10 minutes. And then you have your final trial. So that's it.
Yes.
So between, if your case is taken 2 years and if someone believes that they qualify for spousal maintenance, so income disparity between the parties, maybe it's a stay-at-home parent, someone that's disabled, someone that's been out of the workforce for a long time, they really need to get temporary orders set up as quickly as possible to kind of freeze that claim. And then, like you said, show that track record. Because then again, if the case takes another year and a half, well, you've already been getting temporary spousal maintenance for a year and a half. So that runway is going to be very useful there for you. But as far as child support and spousal maintenance, I'll let Josh talk. There was some recent changes in spousal maintenance guidelines and things like that about income. So I'll let him talk about that. That's still changing, and there may be more changes there, but I'll let Josh talk about that.
Yeah. So prior to this past summer, the way I explained it to prospective clients and clients as far as spousal maintenance is there was essentially 13 different factors under ARS 25319, which basically were the factors that you analyzed to the court at your trial. You said, hey, here's the length of my marriage. Here's what I did to sacrifice for my spouse while they worked. Here's I was a stay-at-home parent. Here's my education attainment. Here's my earning potential. Here's my spouse's ability to meet their needs as well as my needs. Here's the amount and duration I'm requesting. And then basically pleading to the judge, this is why it's fair, right? So it's essentially a 2-part test. One, like Michael said, whether or not you're entitled to it. And then if you are entitled, then the court goes on to that second form of analysis, for what amount and what duration. So prior to this summer, it was just essentially who had the better lawyer, who could put on the case better, right? Who had the better facts. So, and what was happening is, that same case, if you tried it before, 25 judges in Maricopa County, you're going to get 25 different answers and conclusions and response. So essentially us as family law practitioners. And then I know Michael's on the rules committee where he kind of changes these rules and makes the rules for Arizona practitioners. And with that, we came to, we need a calculator. We need some sort of guideline. And that's essentially what was created. And it came out in the summer, I want to say July of 2023, where we finally got it. And the court did go retroactive back to, if your case was filed after a certain amount of date, then you can be eligible for this calculator. But again, it's very complex. The way that the data was generated behind the calculator, it's very easy to put the information in. But if you're in Arizona, what I would just advise you is go to put Arizona spousal maintenance calculator, and then that'll bring up a court website, and then you can start to play with the numbers here and there based on how long you've been married, how many kids you have, what's the principal amount of your mortgage that you have. Some of those things are factored in. And then there's a guideline, a low, a mid, and a high. So obviously, if I am the person seeking the maintenance, I'm going high, making that request. The other side, of course, would ask for low. And then what do you know? The court goes somewhere in the middle, right? So that's been really helpful. And then child support, there's been a child support calculator in Arizona for a while. It's the same type of thing. You can kind of log in there, show what your gross income is, your spouse's gross income, how many parenting time days are allocated to either spouse, who's covering medical, dental, vision insurance coverage. They get a credit for that. Is there child care involved? Extraordinary expenses. Those are some of the data points the court considers. Some are mandatory, some are discretionary. But again, that goes back to, who has the better lawyer to make those arguments. But it's interesting, Kelly, that you say, obviously spousal maintenance, that can be determined of an income for purposes of refinancing or getting approved for a loan. In Arizona, it's important to note that you need a duration in term of at least 3 years to be able to have a qualification for that mortgage, for that financing. I'll let Kelly get into that. Now, what's interesting to me is that child support is considered or allocated as far as income when it comes to being qualified for a loan. Whereas on the eyes of the court, child support is just for the children. That shouldn't be something that you can utilize for expenses or a mortgage. So that to me is interesting. In that field, it's qualified and it's income. But in ours, it's like, no, you could only use that for school clothes, this, that, So it's interesting how we see both sides of that coin.
Yeah, it is. And that 3-year continuance, let's talk about that, because it's so important. And I see so many situations where people are just short of the continuance requirement. And this is across most home loans, if not all. And what I'm saying is that if somebody is receiving spousal maintenance and or child support, and it's a usable form of income for that home loan, the lender is going to want to document that there's a 3-year continuance to document receipt of that at the closing date. So if you're closing, let's say at the end of December, and maybe per that divorce decree, now you're only going to get spousal maintenance for 2.5 years versus the 3 years, then in that case, it's very likely that income will not be usable income for home loan qualification. Same type of scenario with child support. One of the challenges from a child support standpoint that we run into when we're reading divorce decrees and based on the lending guideline 3-year continuance is the age of the child.
Mm-hmm.
So if they're 15 years old and they become adults at 18, and maybe the divorce decree says something like, we'll continue to pay child support while they're in college. Well, once they're 18, they can decide if they're going to go to school or not. And we get into all this kind of gray area, and it just makes it more challenging. So in my mind, when we're consulting people and they're asking these questions, if they're going to be receiving child support with a child that's 15 years or older, in our minds, we're going to kind of err on the side of caution and not use that as qualifying income just because of that 3-year continuance requirement that we know we're going to have to document. Does that make sense?
Yes. And another thing too is child support. It's not something that is permanent. It's something that could be modified with the showing of a substantial and continuing change of circumstance. So, the way Arizona law deals with that is there's a calculator ran, the number is then inputted and it becomes a court order. And if there's an income change or a job change or somebody loses this job and that child support number is reran. And if that number is greater or less than 15% of your earlier order, then that's enough to qualify as a substantial and continuing change of circumstance. So it's not a huge burden, a huge shift to get that number changed. And if that number was relied upon to, for a mortgage or financing, that could be an issue as well. So I can see why the mortgage side of things, you wouldn't, you don't want to rely too much on that number.
Yeah. Well, we have a few minutes left here. What is your kind of top 1 to 2 bullet points or items to just kind of leave our guests with that might be watching this? If you're getting ready, if you're like in the early beginnings of going through a divorce process, or maybe you were just recently served, what are the top 1 to 2 things that you should do today?
Yep. Michael, do you want to start?
Yeah, I'll start there. So, and Kelly, I think this goes back to one of the things you said, which was in those decrees, we need specific items, right? MasterCard, and then, card number, last 4, something like that. I guess the one thing I would tell people is you are also an active person in your case, right? So, and again, it's similar to when you're applying for a mortgage where you guys are going to want documents from them. And the same thing goes for our process as well. So that's Rule 49 disclosures. So essentially there's a list of documents. You need to provide all of these documents. And we're talking, it could even be more. I've applied for a couple mortgages, so I know it's a lot more information than even the home loan processors need. So just being prepared to, unfortunately, you need to be an active participant in that case. I think the attorney, you could have the best attorney in the world. They're only as good as the information that's being provided. So just know you're going to be having to provide bank statements, credit card statements, credit reports. This information is going to be provided to your attorney and then possibly even to the court thereafter as well. So I think just knowing your attorney is going to need some information from you. You are unfortunately going to have to be, checked in for the case and participating and responding to emails and taking calls and doing these type of things. But yeah, and I think Josh hit the nail on the head. Just having your team in place, attorney, depending on the finances of the parties, a CPA, financial expert, the home lending professionals. So I think those are kind of the simplest takeaways I would give. And then the one I talked about at the lead of the show, it's always better when we're talking about homes. If you guys can come to an agreement and work together, it's going to save a lot of time, a lot of money. And you're going to be able to wrap your case up quicker, which means less headaches, less emotional, trauma related to the case. So those would be my high level takeaways.
Yeah. And just to add on to that, I think I have a couple as far as just being informed of your current financial situation within your marriage. It's so shocking and surprising when we have these consultations and we sit down with someone and they have no clue what's on their credit cards. They have no clue what credit cards their spouse has in comparison to theirs. They say, well, we have a joint account that I can take money out or he can take money out, but I don't know what he spends on those. I'm like, so I need to know exactly what kind of assets you have, what debt you have. And then another thing that people don't understand is that your spouse could have a credit card in his or her name and they can have $40,000 on it. And if that was accrued during the course of the marriage, you are equally responsible for that debt. So just having the knowledge and wherewithal of where you are and where you stand in your marriage as far as the finances, I think that's really helpful, because when we get that client, now we have to send out subpoenas to these banks. Now we have to send out the records and get the checking account, the savings account. We have to order the credit report at the beginning of the case to see what accounts. And then we say, oh, by the way, did you know you had a Citibank account? I did not, right? Well, you have $20,000 in debt on the account, right? Well, that's his. No, it's not, right? Because it's Arizona, it's law. So I think that is just being informed, just so that, again, you can take that information and then provide it to your team, specifically your attorney in this case, so we can tease out the issues and see what the assets and debts are and make the arguments from there. The second is we appreciate the calls where, hey, me and my spouse, we're on the same page. We're going to do joint custody, legal decision-making. We just want to split the assets and debts. We want everything to be amicable. Okay. I love that word amicable, but I want it to be an informed, amicable situation, meaning, hey, I know I just agreed on 2 years of spousal maintenance. That's a problem if you want to refinance or you want to purchase this. So don't make agreements if you don't know the legal ramifications of those agreements. So even if it's amicable, sit down with a lawyer, even jointly. There's collaborative divorce methods out there as well. Even jointly say, hey, this is what we're thinking, just so that that person or two people can advise, well, this is what that means if you do this for child support, or if you agree to this amount in spousal maintenance, that'll reduce the child support, right? Or you can do no child support and then do all spousal maintenance. There's different tax implications on all those things as well. So just, again, being informed, those two things. It's great to settle a case and save money on attorney's fees, but then not at the expense of, your 2024 tax bill that no one knows any idea about what it's going to become.
Yeah, that's such great advice. Well, you guys, thank you so much for agreeing to pop on today and share with us all that we kind of need to know as people move through this process. And I know you guys are here local in Maricopa County. I think it's Gilbert, Arizona. So we're going to go ahead and post your website on here. Feel free to reach out to Michael or Josh with questions. If you're going through the process or you know somebody going through the divorce process that needs legal counsel, they are amazing. And as you can see from today, a lot of knowledge going on there. And from a lending perspective, just know that we're here and we are very much part of that collaborative type of conversation. So we know that there's stuff you need to know that you may not be thinking about. And just so really being able to kind of work through that specific scenario is, I think, so helpful to the future outcome. So don't hesitate to reach out to us either. And thank you guys so much.
Yes.
Kelly.
Thank you for having us, Kelly. We appreciate it.
You bet. All right. Have a great day.
See you later.
Thanks, Kelly.